A very good afternoon to you, and thank you very much for being part of this all-important webinar. I want to, on behalf of the partners of Minkah-Premo, Osei-Bonsu, Bruce-Cathline and Partners, welcome you to the MPOBB Academy webinar seminar, which is the first in its series. So it promises to be interesting because the organizers of this program have chosen a very interesting theme. And the theme for this discussion is When Love Meets Property, Legal Rights in Marriage Under Ghanaian Law. There are a lot of interesting things here. The first interesting word is love. The second is property. The third is legal rights. The overall is marriage. And then Ghanaian law. So what it means is that after this discussion, we should have a fair understanding of these beautiful words that are captured in this theme. Let me register that we have some of the senior partners at Minkah-Premo, Osei-Bonsu, Bruce-Cathline and Partners present. We will introduce them accordingly. But we will start with the panel who are here to assist us in this conversation. If you are joining us on radio, you are listening to Asasi Radio on 99.5 in Accra. It's 98.5 in Kumasi. It is 100.3 in Cape Coast and 99.7 in Tamale. If you are joining us on Zoom, you are on the Zoom call of Minkah-Premo, Osei-Bonsu, Bruce-Cathline and Partners. It is the, I don't know how to pronounce the short for it. Is it MPOBB? Yes, okay, I'll use MPOBB. MPOBB Academy webinar series. And we are excited to have you joining us on Zoom. We are told that we already have over 300 people who are on the Zoom call. We are grateful that you joined us. The panel that are going to help me with this all-important discussion, first is Madam Sheila Minkah-Premo. She's Managing Partner, Apex Law Consult, and President of GA Women's Forum. Madam, sincerely, you're welcome. Next on the list is a justice of the Court of Appeal of our beloved country. He's very well known because of his writings and his contribution to the Ghanaian jurisprudence. Please welcome Justice Alexander Osei-Tutu, Justice of the Court of Appeal. And last but not the least is a friend of mine, very good friend of mine, and he's a lawyer in-house here at MPOBB, and his name is William Sanes Mensah. He's the head of family and estate planning here at MPOBB. Willie, welcome. All right. So, for those of you who are joining us physically here at MPOBB, let me welcome you. We are happy to have you in the audience. And when it is time for questions, we hope that you'll contribute your questions and all that. Those who are joining on Zoom, we really thank you for your patronage. And those on radio, thank you sincerely for the courtesy of your company. So let's begin the conversations. And because we have a lady in our midst, we will do ladies first. I'm sure I'm allowed to do that. Okay. Thank you. So, Madam, we want to understand marriage under the Ghanaian law. And so, first of all, tell us, what form of marriage are recognized under Ghanaian law?
Thank you very much. So when it comes to marriage in Ghana, the laws are plural in nature. We used to have 3 separate laws regulating marriage, but they've currently been consolidated into the Marriages Act. So if I will just go to what is the Marriages Act. Under Part 1 of the Marriages Act, we have the Marriages Act from 1884 to 1985. Cap 127. Part 1 deals with customary marriage. And customary marriage was the type of marriage that we had in Ghana, or what is currently known as Ghana, Gold Coast, before our interaction with the colonialists. So part 1 of this law deals with that. Then part 2 deals with the Mohammedan marriage, which is a marriage which is based on Islamic law. When it was a separate law, that is before the consolidation, it was known as the Marriage of Mohammedans Ordinance Cap 129. And this was originally enacted in 1907, when during the colonial time, when the British realized that there were quite a number of Muslims in Ghana, in the then Gold Coast. They came up with a law to enable them to register their type of marriage. And then we also have the Christian and other marriage. This was the law that was enacted by the British colonialists in 1884 to enable people that they had converted to Christianity to have the type of marriage that they had, which was monogamous in nature. The first one that I mentioned, which is the part 1, the customary marriage, that is what we call potentially polygamous. So a man can marry multiple women. And in 1985, a law was enacted, the Customary Marriage and Divorce Registration Law, to enable those who wanted to register their customary marriages to register that marriage and to also register divorces. So it's potentially polygamous. A man can register up to, there's no limit to the number of women a man can register. So it's polygynous in nature. As I said, under the Islamic law, an Islamic man or a Muslim man can register up to 4 women, because that's what their religion allows them to. And this was captured in the Marriage of Mohammedans Ordinance. For the part 3, which is the Christian and other marriage, it's monogamous in nature. So a man and a woman marry to the exclusion of all others. So all these 3 types of marriages are recognized. As I said, they are currently consolidated, but their incidents vary.
Okay, so interesting foundation laid for us means that there are basically 3 types. And it is the Christian, the Muslim, and the customary, and all that. Okay, so let me come to my Lord. And my Lord, I know you may want to make a contribution on the first question, which has to do with the forms of marriage. But beyond that, you can also look at telling us about church weddings. And I believe that will fall under the third the ordinance, which is the Christian and other marriage. So, yes, as you share your thoughts on the first question that Madam has answered, you can step it up by talking about church wedding and whether or not it is legally recognized.
Thank you very much. So, as was rightly pointed out, in Ghana we have 3 types of marriages. And the Mohammedan one, most people are not familiar with it. It is purely religious in nature. That is, if you are not a Muslim, it's not for you. The customary one is for every Ghanaian. Every Ghanaian, if you are interested and you want to marry, but like was pointed out, it is not polygamous. I would say it is potentially polygamous. Sometimes the impression is created that customary marriages are polygamous. Like Madam rightly said, it is potentially, so that if you want to marry 2, 3, 4, 5, 6, you can. If you want to stick to one, you can. But the ordinance one is purely monogamous, meaning that it does not permit the suitors or the couple, the spouses, to be in any other relationship apart from the 2 persons. Yes, coming to the ordinance marriage, the law permits the ordinance marriage to be registered in, to be celebrated in registered places, which include the churches, or in the law says places of worship. But there are conditions also. You don't just go to any church and say that I am registering my marriage. Personally, when it was time for me to register, even though in our church they had celebrated more than 50 marriages before my turn, I told the pastor I ascertained whether the place was registered, the place was licensed, and they had not done that. So I said, I will not celebrate my marriage here. So before you can celebrate your marriage under the ordinance in a church, you must find out whether the church has been registered. And apart from the church, you must also find out whether the ministers celebrating or officiating is also a recognized minister. So you don't just go and there's a formality. I believe most people are aware of the 21-day publication of bans. The law provides that if it will be conducted in a church, at least 3 Sundays, it's come back to the 21-day publication. It has to be announced for anybody who would want to raise a caveat to raise it. So the law permits ordinance marriage to be celebrated in churches, but we need to ensure that in celebrating it, we go by what the law says. For instance, the law provides that an ordinance marriage must be celebrated within certain time frame. That's between 8 a.m. to 6 p.m. So you can't go to a church and fix your marriage at 10 p.m. That will be contravening the law.
Okay, so a very interesting thoughts there by my Lord. So, but my Lord, just a quick follow-up on that. So what it means is that somebody says that I want to do my wedding at the Kumasi golf course. It's an outdoor venue. It's nice garden. And so you are suggesting that you may want to do your wedding there, but you must find out if the place is a registered place to celebrate weddings. First of all,
basically there are 2 ways of celebrating your marriage. Either you go by what the law says, or there's another one which is called special license. That one, you will be given a special license. You may not even have to wait. Let's say you came from UK and have to go back next week. You cannot wait for the 21 days. So you go for the special license, and you can dispense with, once you go for the special license, you dispense with some of the formalities, like the publication of the bans for 21 days and celebrating it at a registered place and all that. So if you want to do it, celebrate your marriage at a place other than a church or registered place or a recognized place, then you need to go for the special licenses to be able to do that. Okay. Otherwise, the celebration of the marriage at an unrecognized place will not be right.
Okay. So I believe that we've laid a very strong foundation about what marriage is. And because of the line of questions that we have, I'm coming to you, William, and we are going into, I think, the issue that is of most interest from the line of questions that I have seen generated from our viewers and registrants, which has to do with property ownership in marriage and upon divorce. So we've laid the foundation as to what marriage is. Now you have no doubt, if you want to choose to go customary, you can go. If you're a Muslim, you want to go by the Muslim way, you can do that. If you want to go by ordinance, go to the church, you now know that you can go that way. But the most interesting part of this whole thing has to do with property ownership in marriage. And William, the first question that I like for you to draw our attention to is whether or not under Ghanaian law, marriages, when you get married, automatically it makes you a joint property owner with your spouse. So assuming that before a man met a woman and they got married, the man owned the house, and then they now get married, does the woman automatically become a part owner of that house by virtue of the marriage?
Okay, thank you, Wilberforce. One important thing we have to note is the definition itself of the matrimonial property. Now, when we look at Article 22 of the 1992 Constitution, it clearly defines what may be termed as a matrimonial property. In that Article 22, it states that it is property that is jointly acquired during the subsistence of the marriage. That is what will be determined or termed as matrimonial property. Now, the question now is whether or not a party to a marriage can own property in their own capacity. We will now refer ourselves to Article 18 of the 1992 Constitution, which gives every citizen the right to own property in their own capacity. So when it comes to dissolution of marriages, or when it comes to divorce, the question that now the court would need to ask or would need to answer is, was the property acquired during the subsistence of the marriage? If the answer is yes, there is a rebuttable presumption of joint property. Now, it lies on the party who is saying that, no, it is my self-acquired property, to now bring evidence before the court to show that, indeed, it is my self-acquired property. Because Article 18 is giving you the right to own property in your own name. So now you would have to lead evidence to show that it is your self-acquired property. Now, the Supreme Court has recently also given guidelines to practitioners and to the courts to determine how the ratio or distribution of the said property should be, where there's the presumption of jointly acquired property is not rebutted. And what I would like to say is, just to touch on a bit on customary law, there's this presumption, or there's this notion that people carry, that when you customarily marry, your spouse or your wife is not entitled to any property. Once you are done with the marriage, you just return her drinks, then you are done for. But the law provides protection for spouses who have proof, or who know that indeed the property acquired during the subsistence of the customary marriage, which is recognized, as Mrs. Premo said, under Part 1 of the Marriages Act, is a validly recognized marriage. You can then come to court and then lay claim to such property. So yes, that presumption is rebuttable.
Mm-hmm. Okay, so it's for those who may be listening who may not necessarily be lawyers or have legal understanding. Once we start talking about rebuttable presumptions, then people are asking, hey, then okay, almost start you on the camp before I can say so. Okay, so I think that in a layman's language, it's like saying that se wo be kan sembia as say what de ehun injina so ba na yehu say ampa ade no ewo. So if you say something, I don't know if I'm explaining it correctly, but maybe the judge will help us so that I don't assume that I'm a judge. But my lord, you can help us on that side by telling us how does the law determine matrimonial properties. You are the judge, so how is the law determining this?
Thank you very much. Let me first explain what we mean by rebuttable presumption. Once you go to court, there are certain, when we talk about presumption, you don't need to prove. Once you lay the foundation, you come out with the facts. The law draws its own conclusion. So once you come to court to tell the judge that you are married, if you are talking about rebuttable presumption, the court then forms an opinion that any property that was acquired in the marriage belongs to the two parties. So there's that presumption. Until, so where you say, no, though we are married, this is how I came by that property. My father died 2 years ago and devised that house to me. So it is, so I am leading evidence to change the mind of the judge. So that basically, if you don't say anything, oh, our for, then the property belongs to the two of you, the couple. So you did not lay evidence. Once you came to court to say that you are married and the property was acquired during the subsistence of the marriage, then the law draws that conclusion for you until otherwise rebutted. That is until one of the parties is able to come out with evidence to contradict the we will say perception, the perception or the what the judge would otherwise have assumed. I don't know whether.
Well, yes. From gauging, I think that people understand. I think so. Okay,
All
but
right.
maybe to the substantive question, which has to do with the fact that how does the law determine matrimonial property?
Yes, my brother mentioned that recently the Supreme Court came out with some guidelines. Let me quickly go through some of them. We have two main decisions that border on the distribution, or two decisions that gave us the guidelines. One was delivered last year March, about a year ago. Aishetu Kadiri versus Abdul Kadiri Dramina. It was delivered on 12th March. What is today's date?
Today is 11th.
11. So tomorrow will be 1 year.
Okay.
12th March 2025. This is what the Supreme Court said, that in determining the whether property is jointly owned or not. One, any property acquired by a spouse or the spouses in the course of life of a marriage, whether customary, Mohammedan ordinance, is a matrimonial or marital property. So once you come to court and you mention that, oh, we married in 1980, but the house was purchased 2 years ago, the court forms that view. Two, a property acquired by any of the spouses before the marriage does not qualify as a marital property. So any property, before we married in 1980, I had that property. So if I acquired a property before the marriage, automatically it cannot, like my brother said, it cannot form part of the marital or matrimonial property. Three, acquisition can be so, that is by one of the spouses alone or joint. So whilst in the marriage, it's possible for one person to acquire his own property. You went for a loan, or like I mentioned that your father died and property was devised to you. It's for you alone. The other spouse may not have any role to play in its acquisition, or it can be joint. Okay, the way things are going, let me take care of the building, and so from now I'm not going to give house maintenance money. So, or you take care of the children or their school fees. So we make some arrangements. At the end of the day, it's presumed that the two parties contributed in the acquisition of the property. 4, the constitutional formula for the distribution of properties acquired in the life of a marriage applies only in relation to jointly acquired properties. So basically, we are talking about jointly acquired property. So any formula does not relate to an individual's own acquisition. 5, where the property is jointly acquired by the parties to the marriage, the same must be equitably distributed upon the dissolution of the marriage. In certain situations, equality will be equitable, and in other situations, equality will not be equitable. Each case must be treated differently. For some time, the presumption was that 50-50, but the Supreme Court is saying that no, equality cannot mean equity cannot mean equality. Where we acquired a property, we contributed. I contributed 70% or 80%, and you contributed 20%. Do we say equality means 50-50? So as based on, it should be proportionate. So that's what the Supreme Court is saying, that equality is equity principle does not necessarily mean it should be 50-50. So each case must be, it's very important, each case must be determined on its own merit. And the sixth, where the acquisition is supposed to be a joint acquisition, the fact of the property being jointly owned is not contingent solely on financial contribution, but other means of contribution, whether in kind, material, or otherwise, but for which the other spouse could not have solely acquired the property. So now some lawyers or some people think that with the current trend, the Supreme Court has moved away from the Mensah versus Mensah, where property, it was held that property jointly acquired could include other forms of contribution, like the husband providing domestic services for the wife, providing domestic service, ironing the husband's clothes, washing them, entertaining his guests, and all that. The Supreme Court still recognized that. And next is whether or not acquisition is joint is dependent on the special and peculiar facts of the marriage and the circumstances leading to the acquisition. So the circumstance, like I gave an example that, I acquired a property. How was I able to acquire it? We made arrangement that you take care of the children's school fees. So the circumstances will be considered. And 8, the settlement of an interest in a jointly acquired property, marital property, can be converted to monetary terms where the special circumstances of the case warrant, and as sanctioned under Section 20 of the. So, yes, it's possible that you might have acquired it. My contribution may be minimal, but the court has the power. If you look at Section 21 of the Matrimonial Causes Act, the court has the power to make an order for one party to convey. She might not have contributed directly to the acquisition, but some other role she performed. It's possible that a property belonging to even one person, where the other person was not directly involved, could be conveyed to that person. Yes. And lastly, despite being marital property, the property may, upon the dissolution of the marriage, be settled on only on one of the spouses or as being the sole owner of the same. So it's possible for the court to say one person should take everything, looking at the circumstance.
Okay, so the conversation is getting interesting because it looks like this practice direction that my Lord is talking about leaves a lot of discretion to the court to deal with issues of property ownership in the event that a marriage is about to be dissolved and all that. Madam, I'm coming to you now, Madam Sheila Minkah-Premo, to also share your thoughts with us on this issue about property in marriages. Maybe you can focus a little bit more on what happens when property is registered in only one spouse's name. I know my Lord touched about it. And then also maybe can company-owned property be considered part of matrimonial property during divorce?
Thank you. When it comes to property that is, let's say, the two people contributed to, but it's registered in the name of one person, then based on the Matrimonial Causes Act that my Lord referred to, it is possible for a person to indicate that, look, and I think under Section 21, this property I contributed to it, but it is only registered in one person's name. So the court should look at the facts of the case and give a share, an adequate share based on some of the principles. There's another law which is also very important, which is the Land Act, 2020 Act 1036, which also has provisions which is also based on the Constitution, the same Article 22 that has been mentioned by
By William.
Pardon me.
By
Yes,
William,
William, yes. So I think section 38 and I think 47 have provisions indicating that if a person is registering property and the person is married, there's a presumption that it is for the person and the person's spouse. And therefore, they are deemed to be joint owners. Sorry.
Okay.
There's a presumption. There's a presumption in the law which says that it should be registered in the names of the two people, unless some contrary thing is stated in the face of the conveyance. So, based on this law, then there's even another part of the law which says that in such circumstances, it is possible to get two land title certificates in the two names. The law is there, but the practices of the Lands Commission is not really implementing it as far as I'm concerned. And therefore, in many cases, people at the end of a marriage, when someone is laying claim to property that they say they contributed to, they would still have to go to court as part of, we all know that in matrimonial matters, apart from the dissolution of the marriage, the court looks at ancillary issues, one of which is property rights, and the court would go into it. And if a person is able to bring enough evidence to show that, yes, I contributed to this property, but it is registered only in the name of my spouse, then the court will go into the matter based on all the principles that we've heard here today to determine whether or not a share should be given to that person. And it's possible for the court to make an order for some kind of if it makes an order that they are joint owners, they can ask for either monetary compensation for that person or for some form of conveyance where it is possible. With regard to commercial property or assets which are owned by a company, usually those are different because the law regards a company as a separate legal entity. And therefore, if property is in the name of a company and there is issues about shareholder, properties are in the name of a particular company and the other person is not a shareholder or doesn't have any interest in it, then it's difficult to lay claim to it. But there are instances, you recall the Mensa case of 2012, which my lord referred to. In that particular case, some of the things that the petitioner, who was the woman, was claiming was that in the course of the marriage, based on the contribution, the work that they did together, a company was registered at a point, but because she was an illiterate, it was registered, the shareholder was the man only, but she worked with the company, even though she didn't provide adequate evidence. The evidence from some of the witnesses of the husband confirmed that she had a part to do with it. The court gave her a certain interest in some of the assets that have been acquired in the name of that company. So strictly speaking, company assets are not parts, but depending on the facts of a particular matter and issues to do with equity, the court can sometimes lift the veil, see what went on, and then give the other person claiming a share, some portion.
Indeed. All right. So if you are just tuning in on Zoom, you are part of an ongoing Academy webinar series, MPOBB Academy webinar series, taking place here at the offices of Minkah-Premo, Osei-Bonsu, Bruce-Cathline and Partners in Labone. And the topic under discussion really is when love meets property, legal rights in marriage under Ghanaian law. If you are listening on radio, on Asasi Radio, this is what you are tuning, and I believe the conversation is getting interesting. All right, so William, I want you to quickly talk about this, and my lord and my lady, I'd like you to think about this while I go to William. I heard somebody talk about trustee incorporation. The fact that globally people are moving towards the direction of creating trust with their properties for their families instead of willing it to them and all that. And they are saying that when there is that trust, it protects properties even post marriages and post life and all that kind of stuff. I want you to think about it, whether or not it comes to play. I know in Ghana we have a Trustee Incorporation Act, 1962. Nobody seems to talk about that act anymore. But I want the two of you to think about it as I go to William, and that will, after William's comments, then we will dovetail into that trustee issue shortly, and then we'll move on from the conversation. So, William, can you quickly touch on how does the law treat property owned outside Ghana in the event of divorce? And when I come to Madam Sheila and my lord, you can also make contributions to that. But property outside the jurisdiction, how is it treated?
Okay. With property owned by parties to a divorce, one of the important things you have to notice under the laws of Ghana, when you look at Section 1 of the Matrimonial Causes Act, it spells out how a party can bring a divorce to a petition for divorce to the courts. One of it being you must be a citizen of Ghana. That's one. 2, you must be domiciled in Ghana. 3, you must have been ordinarily resident in the country for a continuous period of 3 years preceding the said divorce. With this, it's important to know that even if the properties are outside the jurisdiction of the courts can make pronouncements on the distribution of the said properties. But what is important is the enforceability of the order the court will make in terms of the distribution of such property. So let's say, for instance, the parties have properties in the United Kingdom. They are seeking divorce in Ghana and distribution of the properties based in the United Kingdom. What you have to note is that there should be enforceability, reciprocity of enforceability between the two countries, so that when you get the order or your judgment in Ghana, you should be able to enforce it in the United Kingdom. There is an LI in place which states the countries to which Ghana has a reciprocal arrangement with, to which the United Kingdom is a party to. So once Ghana and the United Kingdom are signatories to that particular treaty or LI, when you get a judgment here and the court says that, let's say, the petitioner is entitled to 2 of the properties based in the United Kingdom, all you have to do is register that order in the courts in the United Kingdom. The LI spells out which particular court you have to go to. So then you can enforce that order that has been given in Ghana. The problem or the challenge will be where there's no reciprocal arrangement with the country where the properties are based in. So if it's a foreign jurisdiction and there's no reciprocal arrangement, then enforcing the orders given by the courts in Ghana will then be a problem. So it depends on the existence or non-existence of the reciprocal arrangement. Yes.
Okay. So in other words, you cannot hide property outside the jurisdiction from a partner in the event that there is a divorce. Once the property is known, you cannot perhaps arrogate it to yourself alone. Based on the legal provisions that you're talking about, the fact that you said there's an LI that you can rely on and then get all that. So it's possible that you can own a property outside during the subsistence of your marriage, and in the course of a divorce, both parties can benefit from that property irrespective of where it is located.
That is so. If it's brought to the court's attention that there is a property in the said jurisdiction.
I see that my lord wants to make a contribution to it.
He indicated how the jurisdiction of the court can be invoked. So if the parties are able to invoke or properly invoke the court's jurisdiction and they succumb to the jurisdiction, then the court is enabled or empowered to make orders affecting properties outside the jurisdiction. There's one case in point that maybe the lawyers may be interested. Gilbert Anyitei versus Suzanne Anyitei, civil appeal number J4/67/2021. It was also decided in March 2nd March 2023. The Supreme Court made orders affecting properties that were outside the jurisdiction. So nobody force you to come, but once you qualify to invoke the court's jurisdiction and you succumb to it, then it's within the court's power to make orders, notwithstanding the fact that the subject matter may be outside the country. And so that is one issue. As to how it may be enforced is also another thing. Like my brother said, you need to also, there's a procedure. But I think your question mainly was whether the court is has jurisdiction or can make orders affecting property outside the jurisdiction.
And the answer obviously is yes. Okay, so there's a lot more to talk about in this conversation. So there are issues such as prenuptial agreements that we need to talk about. We need to talk about divorce and separation. We need to talk about joint property and registration and all that. But what I just chipped in, I want you to help us. Is there anything of that sort that is of interest to us as a jurisdiction when it comes to issue about trust? That should people be going that direction instead of saying that they've willed the property to someone? I don't know if it's even a subject of discussion here in Ghana or it is not. My Lord, maybe you should help us first and then I'll come to Madam. I don't know if the question is too difficult.
I would want to approach this from prenuptial agreement. For those who have been following me, I think I wrote an article on about 6 years ago that it does appear that in this country, because it's not clearly stated in our law, black and white, people think prenuptial agreement is for the Westerners. And in my article, I referred to cases like Champon versus Champon and other decisions where Atta versus Atta, where the Supreme Court said one of the considerations in determining property, marital property, is whether the parties had made an agreement on their own. Like Madam said, if you go to the Land Act, Section 38, you go to Section 47, they all permit the parties to make their own arrangements. For example, in respect of Section 37, which presumes that property jointly acquired, belongs to the two parties. There's a caveat that unless otherwise agreed to the contrary, meaning that the parties can agree to the contrary. You go to Section 47, which requires that of the Land Act, which requires that in alienating any property in marriage, you need the written consent of the other spouse. Over there too, there's an exception which permits. So all these exceptions permit the party themselves to make their own arrangements so that the general the general principles will not apply. And specifically, in the case of Emmanuel Obin versus Kate Nyameche, aka Mary Frimpong, the Court of Appeal unanimously held that since a marriage is a contract, the parties have the right to enter into a prenuptial agreement by which their rights to create their individual property will be outlined. So, at least by that decision alone, we can say that in this country, prenuptial agreement is lawful.
So, in other words, you are suggesting that before two people get married, they can go and see a lawyer, and the lawyer drafts an agreement which says that in our marriage, if we build a house, the house belongs to me, the man, not you, the woman. Or it belongs to you, the woman, not me, the man. And once you agree to that, it means that it will be binding in the event that that marriage is about being dissolved.
Exactly.
Oh, wow.
Exactly.
Okay. All right. That sounds interesting. I don't know what the audience think. And those of you who are watching us on Facebook and on and all the other spaces. Madam, I don't know if you want to chip in as far as this this question is about. I think that I don't know whether you used that in answering the trust question. Is that what you did, my lord? But you, okay, if yes.
Okay, thank you very much. So what I'd just like to add to the prenuptial agreements issue is, I mean, I'm aware that there are quite a number of these type of agreements that have gone to court, and the courts have enforced it. But my interest is in what a possible law would look like. This one of the things I've been following over the years is a draft property rights of spouses bill, And in the various versions of that particular bill that has been made available, there's a whole section on, they call it marital agreements. So it indicates that prior to a marriage, in the course of a marriage, the parties can come up to an agreement when it comes to issues to do with property. Such, a prenuptial agreement cannot include anything to do with children, etc., but just about property, etc. But there are a lot of protection that is also put in that in the provisions that were developed, because sometimes the one who is maybe the poorer person maybe succumb and agree to something that, so the court can set it aside based on duress, undue influence, etc., etc. And for me, if the provisions actually come out, it will make it easier for people to easily enter into such agreements, and for those who are vulnerable to be protected. On the issue of trust, first of all, the Trustees Incorporation Act, it is in our books, but the reality is the process for registering under it is not non-existent. It used to be an officer based at the Ministry of Lands who was responsible for it. There are a lot of institutions that were originally registered under it. They are still there, etc. But new ones, they will not allow you to do that. I know that lots of people are entering into what they call their living trust or something. But the key thing is that you have to ensure that it is properties that you own solely, not properties that somebody else has an interest in. Otherwise, issues would arise. What I also know is that in many wills that are prepared for people who are quite wealthy, they would always have, or people who think that they have other dependents who they want to protect in case they die early. There are provisions, a part of the will sets up a trust where they will indicate which is a trust property and the kind of protection that should be given it. And personally, I've handled a few of such wills, and those trusts set in the will are usually complied with, and it's usually helpful in protecting dependent children in particular, etc. But the key thing is you can't use property in which somebody else also has an interest in a trust. It has to be one that you own absolutely, solely your property. And it's a way in which, yes, you can protect vulnerable members of your family.
To a trust.
Through a trust, yes.
Okay. All right. So, William, without making you offer legal advice for free on the radio and all that, there's a question here that one of our viewers and registrants asked, and it has to do with how best should couples register property? Should it be jointly, individually, through a trust, which we have just spoken about, or through a company? I don't know which of the options you are going to recommend. When you ask a lawyer a question, he has to think about it. So please allow him.
So that it doesn't seem as an advice. Well, from the discussions that are going on now, Mrs. Premo has touched on the Lands Act. My lord has also touched on how the courts perceive properties that are jointly acquired during the subsistence of the marriage. So looking at all this, even if a party to a marriage registers the property in his sole name, when that property comes up for distribution during a divorce, the court can make a pronouncement that it is a jointly acquired property and it should be distributed among the parties. So you registering the property in your sole name will not really safeguard your interest in the property when it comes to distribution during divorce. I'm a strong advocate. We hope as time goes on, my colleagues know when as a man you want to protect your property, not to sound off as an advice. One of the ways I believe will come off as safeguarding your interests is gifting that said property. Gifting it
to somebody outside the...
That I cannot say, but okay. I mean gifting. As lawyers, they know what we are talking about. My lord knows what I'm talking about. That will safeguard you, because there are exceptions to the rule on how the court will look at jointly acquired property. My lord gave some examples where you come to court and say, no, this property was willed to me. Where a party has gone for a loan, you've not been able to pay off that said loan. Where that property was gifted to you. Under these three instances, the court cannot construe the property to be jointly acquired. So I believe these three methods can safeguard your interest in the property.
All right. So if you are just tuning in, you are listening to an ongoing webinar here at the Minkah-Premo, Osei-Bonsu, Bruce-Cathline and Partners law firm here in Accra in Laboni. And the conversation is on the theme, When Love Meets Property, Legal Rights in Marriage Under Ghanaian Law. And I have three distinguished personalities who are helping with this conversation. Now, I want us to move this conversation to an area where, personally, as an individual, I always frown talking about it. But it appears it is a reality. I was looking at the 2021 census that was done here in Ghana, and the census indicated that about 500,000 Ghanaians are divorced. And so it would appear that you might not like the word divorce or separation, but it is a reality in our republic, and it is a reality globally. And so we need to talk about it. And I'm going to start with you, madam, on this. So, divorce and separation. How can someone properly terminate a marriage legally if they lost track of their divorce case? Difficult question.
So the question is not
The question is not clear. Okay. Okay, so let me rephrase it. So let me just rephrase it and say that how do people in Ghana go about, or how should people in Ghana go about their divorce in the event that they want to divorce? What are the avenues available to them to go through that process?
So if people are not happy in their marriage, the best way to deal with it is to apply for divorce through the courts. And the Matrimonial Causes Act of 1971, Act 367 that we have, indicates that the sole ground on which you can get divorce, especially, is through if the marriage has broken down beyond reconciliation. And in establishing whether or not it's broken down beyond reconciliation, there are a number of grounds that you can prove or establish. You know, one, that there's cruelty. One, that there's desertion. One person has deserted the marriage. Well, where there's cruelty is also the same as unreasonable behavior. Where the parties have also not lived together as husband and wife for 2 continuous years, with the consent of the other party, the court can also grant it. Or where they've not lived together as husband and wife for 5 continuous years, the court can also grant it. So if you want to be able to use facts to prove any of these, then you can apply for divorce. So this law was made primarily for those married under the marriage ordinance, the Christian and other marriage. But Section 41 of this law indicates that if you're married under any other form of marriage, you can also apply for a dissolution of that marriage. But if your marriage is a customary law marriage, under customary law, there are processes that can be followed. You know, among the different ethnic groups, there are different rites that can be performed to dissolve a marriage, and it is usually preceded by some kind of mediation. You'll try to mediate if it doesn't work out. Yeah. For those married under the Mohammedan law, they also have their system. There's this in law school. They teach you about the system of they call it talaq, etc., where you can also follow. But any of these 2 types of marriages, if you're not happy with how the processes that are involved, you can go to court, relying on Section 41 of the Matrimonial Causes Act to also apply for divorce. On the issue of separation, remember that when the Matrimonial Causes Act indicates that if you've not lived together as husband and wife for 2 continuous years, it's one of the grounds on which you can start. So unofficially, you don't go to court to go and say you're going to ask for separation, but physically you move apart or whatever it is. Then after a while, you can apply. Also with the 5-year one as well. But like I said, the 2-year one requires the consent of the other party. So separation is a temporary thing that people can do by themselves, and they can rely on it to ask for divorce later. But you don't go to court asking for an order for separation.
So in other words, separation is not the same as divorce?
No, it is not the same. Separation is where the two people, for whatever reason, physically move apart and stay separately, and then after a while they go to court to formally apply
so
to the
two
court.
people may be separated, but technically speaking, they are still married
That is so.
because
They can be
haven't-
separated for
Mm.
10, 15, whatever number of years. They can, yeah. Then I don't know, maybe one part of your question talked about something to do. Is it the certificate issue you're asking about, or it's not? This is just about separation and divorce.
Yes, separation and divorce. Yes,
Okay.
that's exactly what I was talking about. Okay, I want my law to come in and to also shed some light on this same question. But as you do, you can also see whether it is possible. You can also consider talking about whether it is possible under Ghanaian law to have a contract marriage with a predetermined duration.
Okay. Thank you very much. I would want to first touch on the divorce and the separation. In other jurisdiction, separation, there's a procedure for separation. But in our jurisdiction, separation is only one of the grounds, or a ground that could enable the court to grant an order of dissolution. So we don't have a special procedure for separation. In Ghana, we don't have any procedure that, sometimes I know the lawyers, some litigants, I want separation. Let's go to court. In Ghana, we don't have anything like that. You can't go to court for an order of separation. But if you think for many years, you think that the marriage is only existing in name, then it's important that you go to court for dissolution of the marriage. Because if you do not go to court and should something happen tomorrow, legally the marriage will be subsisting. I don't want to mention any life case, but legally the marriage will be subsisting until the marriage, if it's under the ordinance, the marriage had been declared as dissolved. And I would also want to touch on what we call annulment. Annulment, and you can go to court to say that though we thought we were married, in the eyes of the law, we were not married. So the court should declare that the marriage technically never existed. So there are two ways of getting yourself out of a matrimonial, an ordinance marriage, where the marriage was properly conducted or celebrated in accordance with the law. Then, if it has to be terminated, the court may have to decree for dissolution. But where, in the eyes of the law, the requirements of the law were not met, you can go to court to say that, though we married for, or in the eyes of the law, we married 5 years ago, the marriage was never consummated. There was no consummation. So the marriage was not completed. The process was not completed. And for that matter, the court should declare the marriage as never having existed at all. And that will not be for dissolution, but for annulment. Yes. Now, coming to Section 41, I have always, the way I understand the provisions under Section 41 for your customary marriage to be dissolved, my understanding of the law is that it's only ordinance marriage that can be dissolved by the Matrimonial Causes Act. For instance, the requirement is that where the marriage has broken down beyond reconciliation, and the first is adultery, where one party has committed, and customary marriage, you can be in the relationship and also cohabit with another person. So once you come there, you are completely off. But it does appear that where there are ancillary reliefs, then the law permits you to bring application to the court for those, like So customary marriage, my understanding, is dissolved customary. But when the marriage was dissolved, there were some outstanding issues. How the man should push me off was not considered. There were children in the marriage who takes custody of the children. Was not considered. So the ancillary issues, if you are aggrieved, then under 41 of the matrimonial causes, that is like, it's a personal understanding or opinion. I may be wrong, but that's my thinking. That 41 only enables a party to come to court under the ordinance to seek ancillary reliefs, but not necessary to get the marriage dissolved. That's my understanding.
Okay, so interesting thoughts being shared on this issue about divorce and separation. William, so let's take a quick look at this, and then we can. Yes, please.
I think there was a last part I did not tackle. Marriage of convenience. You did mention that.
So the fact that the marriage is a contract with a predetermined duration.
Okay. In the case of Ernestine Abuatin versus Felix Sewa and two others, civil appeal number J4/08 2020, dated 14th April 2021. The Supreme Court deprecated the marriage of convenience as not being part of our laws. So marriage of convenience is void. Where you marry, you enter into marriage based on love and affection, but where in entering into a marriage is expected to succeed till what we always say, till death do us part. But where we say, oh, let's enter into marriage for 5 years, no, that will be marriage of convenience, and I believe it will fit into the description that the Supreme Court says cannot be permitted to stand. But let me also say that where a marriage is declared void, like a marriage of convenience, but during the period the parties acquire property together, ordinarily you say that once the marriage is void, anything born out of a void relationship is void. But the law, there are instances where a marriage may be declared void. For example, somebody enters into a person married under the ordinance enters into another marriage with a third party, when we all know that ordinance is purely monogamous. That second marriage is void. The second marriage, because of the ordinance, is void. But the law permits rights to be acquired by that person. In this case, for instance, though the Supreme Court held that the marriage was a marriage of convenience, the court made an order for the other person because he had contributed. So technically, it's only a couple in a properly in a proper marriage who can benefit from the provisions of the law. There are exceptions. Another exception, those familiar with Gregory versus Tando, where the parties were in a concubinage relationship. The Supreme Court had in Marian 2015, Justice Akamba, said that all these rights we are talking about are applicable to persons who are properly married, but not in persons in concubinage relationship. But in Gregory versus Tando, the Supreme Court held that though they were in concubinage, the other person had contributed. So not a proper marriage, so-called, still rights were acquired. And also, so if you are in a bigamous relationship and you had committed yourself, it's possible. We also have Francis Owuo versus Owuo 2020, I think 2021, where the Supreme Court held this man was married under the ordinance and went ahead to marry again without the lady knowing. And the court found out that it was fraudulent. But notwithstanding that, the property was settled on the woman.
So in other words, my lord, I hear you saying that this thing they call side chick, somebody could have a side chick, and even though the side chickism is
so if the side
no,
chick help
that
you
side
to
chick
acquire the property,
can still acquire rights.
yes, where she contributed.
So there must be evidence to show that she actually contributed.
Exactly so.
Okay, interesting. Very interesting. Okay, all right. Now this issue about side chick issue is a big issue in our country because of some obvious reasons which we don't want to discuss here this afternoon. But I want us to, looking very soon, we'll come to those of you who are with us on Zoom and those who are on Facebook. We'll come to you so that if you have any questions, I've seen that Norman has raised his hand. Is it Norman Williams? So I'll come to you guys in about 15 minutes time. And then I see AA has also raised his hands. I'll come to you so that we'll give you the opportunity to ask questions, and then we'll continue with the conversation there. Can we quickly take a look at, William, this issue about when divorces happen and it comes to the issues about children? I don't know whether you have all the expertise to talk about that. I believe you do. About issues about children. In the event of a divorce, what really happens to children? Who should have the right to have the children? Is it the man? Is it the woman? Does the law say anything about that? Can you help us? And it's also open to...
before you go to him, let me clarify this point. Otherwise, it will go out there that, now side chicks can acquire rights. In all these cases, they did that without knowing that the other person was in a relationship. They did not know. But where side chick, you are aware that the man is married, and you think, you are side. That case, I doubt whether the law may come to your aid. But in all the situations we are talking about, so the person thought she was lawfully married to only one man.
Okay.
For it to later turn out that the man was married somewhere. So let's put it in its proper context.
Okay, so that also brings another dimension to the conversation, because, and I think, my lord, it's good that you brought that clarity because of how wide this conversation is going. So I think it's good that you brought that clarity. Can we move on to talk about the issues about children in a divorce situation?
Yes, I believe so. But I'll just to touch on what my lord said. You see, this topic of side chicks creates a very big vacuum. So are we saying that side chicks, third party rights cannot inure to side chicks? Even if they knew the party, let's say the man is married, but then again they contributed to the acquisition of a property, are we saying that because they knew the side chick would not have any proprietary rights or any equitable interest in the property that she acquired with a married man? So these are things that I believe when it comes up, we should be able
I know you are asking a rhetorical question, but what's your view on it?
No, you see, I'm saying this because of the recent case of Vince Conto versus Ernestina Togbo, right? Where two parties were, let's say, what we call in the local parlance, impenetrating. Now, the man brought an action to evict the said lady from his property. She counterclaimed, or she also brought an action in the same action, to use layman terms, to say that she shouldn't be evicted because she has an interest in the said property. Because during the construction of the house, she played a supervisory role. Now, the court, in giving its judgment, then went ahead to say that, yes, there was a creation of a constructive trust in favor of the defendant, that is the lady. Went ahead to give damages to the tune of 200,000 and award her a car. So, indirectly, invariably, the lady was not evicted, walked away victorious. I mean, it's up for appeal. hopefully comes before my Lord, and then they give pronouncements on it to say if we are talking about constructive trust, where you are saying that, so the fact that she supervised the construction of the house alone should inure to her benefit for her to be entitled to the said property. So that's a ruling or judgment we are favorably, or we are hoping will bring some clarity to the issues that has been raised. Now, to go to the issue of the children, the Children's Act specifically speaks on this and says that when it comes to custody of children, what the court will look at is the best interest of the child. So a lot of people have the view that when it comes to custody, the child should be granted to the woman, but that is not the case. It should be the best interest. So when the court looks at the peculiarity or circumstances surrounding the case and finds out that yes, indeed, the man is more suited to take care of the child, then custody can be granted to the man. So in summary, it is the best interest of the child that the court will look at. It's not the gender of the parent, so it's the best interest. Yes. So
okay, best interest of the child is always obviously best. I don't know if my Lord wants to add anything to that. Yes.
Yes. I agree with my brother. In fact, if you look at the case of Gregory versus Tano, 2011 2 Supreme Court of Ghana Law Report, page 971, where the Supreme Court held that the parties in a concubinage relationship were not entitled. This is what Akamba said at holding 4. Although the plaintiff is not a spouse of the first defendant, it is permissible for us to grant her a beneficial interest that is proportionate to her contribution. If you look at the, you read the decision carefully, the Supreme Court relied on 2 things. One, that she was not married, and 2, that she did not contribute. So if you are able to make a case that yes, you are not married, but you contributed, I think the law may come to your side. And also in this case of Isaac Owusu-Chum Ampofo versus Adelaide Ampofo, 2016, 96 Ghana Monthly Judgment, page 81. The Court of Appeal decided at page 87 that although the respondent did not make any financial contribution towards the construction or renovation of the house, but by supervising the building, at least at the initial stages, he had contributed to the property's acquisition, was entitled to a share. So where the person only supervised the construction, the Supreme Court felt that she should not go home empty-handed. So, and also, Lydia Kwao versus Pascal Mwako. Lydia Kwao versus Pascal Mwako. Civil Appeal number J4/32/2019. Delivered on 22nd July 2020. The Supreme Court held that the Matrimonial Causes Act does not discriminate between divorce and nullity of marriage. So where your marriage can be, in the eyes of the law, not be recognized, but where there has been some sort of contribution, or where the justices of the case demand that you should go with something, it's within the province of the court to award that to you.
Okay, ma'am, yes, quick contribution on that, yes.
So on the Sylvia Gregory matter, if you look at the facts of the case, the woman was not Sylvia, she was not a Ghanaian, and the man gave her the impression that he's married a customary law to his wife, and he's allowed, as a chief, he's allowed to have additional women. So she actually acted on that and she was able to provide evidence to show what she brought. She was an African American woman. She brought money for them to run the transport business and so many things, and a lot of properties were acquired from it. So as has been indicated, the court said they will not allow, even though whatever ceremony was performed was not recognized by our law, they sort of did some business together. There's even a high court case which we've been using for a long time. It's called Usunyako. It's a 1980 case, GLR 428. In that case, the woman and the man were both in the Western region farmers. They cohabited together, had 2 children. They planted a cocoa farm. And in those days, that particular brand of cocoa would mature in 8 years. On the 7th year, the man said the relationship was over. She went to court to make a claim for 1/3 of the cocoa farm. The man brought evidence to show that Mpnawari is not recognized, blah, 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 blah. The court said, yes, it is not recognized. You have evidence from, he had witnesses, queen mothers, etc. But they said that the business they undertook was like a business. So the court, even though the relationship is not recognized by law, the court will not sit down for another person to exploit the other. So they gave her 1/3 of the farm. So as has been indicated, it's not just a blanket thing. If you're able to show that you actually contributed, then you're able to also benefit from it. Then also commenting on what William indicated, yes, the principle is that the best interest of the child is the big yardstick. But the Children's Act also says that when the children are very young age, and there's case law to the effect that when they are very young, infants, then usually they would let them stay with their mother unless there's something about the mother's circumstances which will not be conducive to the children. And then based on what is in the best interest of the children, it could be either of the parents.
So you are suggesting that the law somehow gives a little bit of an advantage to the
mother for very young children.
For very young children,
yes,
as against the father.
Yes.
Okay.
When they are very
so
young.
Young as in what, 1 to 10 or 1 to 17?
Young children who are dependent on their mother for their, up to, I think it's, let's say up to 12.
Okay.
Usually around that age, that is when some of the cases show that to that effect. So they would usually give them to the mothers, unless.
Okay. So before we go to, we come to the audience and also go online for questions. The last part of our conversation will probably be on the issue of death, wills, and all that. So we are born, and we certainly will die. Some die leaving a will, others die without a will. And most of the time, I know you are lawyers, so you'll be able to educate us on the provisions of the law if you die with a will and if you die without a will. And when it comes to issues of marriage and inheritance, how do we handle it, or how does the law handle that? And so I'll start with you, my lord, to brief us on that, and I'll go around, and then after that, we'll come to all the hands that are raised and all the audience who are here. My lord, we are in your hands.
Yeah, so whilst alive, if you make a will and you die, you are deemed to have died testate. And the provisions of the law, the will prevail. But if you did not make a will, then the law would determine for you who should inherit you, who should succeed you. So it's PNDC law 111 that regulates, as we are familiar with, intestate succession law, that regulates the estate of those who died without making wills. The law permits certain categories of persons to go to court when they are excluded from wills that were made by the deceased whom they depended on. For instance, if a man makes a will and leaves the spouse, the wife out, within 3 years, the spouse is permitted to go to court for a reasonable portion of the estate. The same thing goes for the children who were dependents, who depended on the testator, as well as the parents of the deceased. Again,
so essentially, you've mentioned 3 categories: the wife, children, parents.
Yes.
Okay.
Again, in respect of grandchildren, where let's say a man made a will for 4 of his children, but one of them predeceased him. But before he died, the person had a child. Under Section 8 of the Wills Act, in sharing the property, the portion that would have gone to the deceased father of the grandchild and child of the disease. I don't know.
I get it.
Uh-huh.
So a man had a child, and that child also had a child.
Yes.
But the first man, may have died. But before he died, his son, who is in the middle, died before him.
Yes.
So if that man at the top dies
and made a will
and
for
made
the
a
son
will for
who
the son,
died before him, that property will go to
his grandson,
grandchild.
Yes. Okay. All right.
Also, grandchildren who were dependent, when it comes to, that is in respect of wills. But where the person did not make a will, the interstate succession law, section 16, permits grandchildren to, who also depended on the
deceased,
on the deceased.
Okay.
Yes, to also get the share of, just like the other one, the share of the property that would have gone to the parents. So basically, that is. But when it comes to the interstate succession law, there's a formula for sharing the properties. For instance, if the deceased left behind only matrimonial home or one house, that property completely goes to the surviving spouse and the children. It also goes with all the household chattels. And if there are cars other than commercial, that's private cars, even if they are 20, they all go to the surviving spouse and the children. The family has no share in these properties. So household chattels, and private cars. Beyond that, the family will be entitled to any other the remainder, and that one too, there's a formula. What goes to the children, what goes to the, for instance, where the disease died, leaving behind the spouse and children, the parents, 9/16, after the nuclear family had taken all that, 9/16 will go to the children, and the spouse will take, I think, 3/16, and the remainder shared between the parents and the extended family. So there's a formula for sharing it. But I always say that it's better that you do it yourself. You don't wait for somebody, a law. The judge, when you were sweating, the judge was not there. But because you failed to make provision for your dependents, somebody will come and determine how your estate should be distributed. So we encourage everyone to make a will. You determine. Unfortunately, we all think we are not near death. So me, for instance, I have not made my will, thinking I have many years ahead of us. But when death knocks, it may be too late for you to go and make your will. So we should try as much as possible to make our will so that we share our properties the way we want it, rather than leaving it for the Lord to share our properties for us.
I think my Lord has answered the next question I wanted to ask Madam, but I will still find a question for you. But one of our listeners has just sent me a decision from Kenya, which says that Kenya court rules fathers can get custody of minors. So the person has just sent me a decision in a Kenyan court about what, Madam, you were talking about, the fact that the law in Ghana makes room for our mothers to have custody of children who are younger.
That's what I'm saying, but there are conditions.
Yeah.
You understand?
Okay.
If there's something about the woman's condition which is not conducive for the children, the court can still give children to very young children to the father.
To the father. Okay.
Yes.
So I'm unable to read the decision that has been sent to me, but Amos Kevin Annan is the one who sent it to me. He's listening to this conversation, and he just sent it to me via WhatsApp. Okay. So I'll take quick thoughts from the two of you on the issue of wills and all that when it comes to marriages and all that. Just to add to what my Lord has said. Yes,
Okay.
my
So
lady.
what I'd add, I think my Lord has said a lot of what the law says. What I'd like to add is that there was an amendment to the intestate succession law by the Children's Amendment Act, which indicated that if there are children of school-going age, then the laws permits provision to be made for them before the sharing in accordance with the intestate succession law. And it's very important to mention that. And then in addition, the intestate succession law also has some protection for spouses. Sometimes when somebody dies, even before, the law requires that you don't just share, you have to, if it is intestate succession, then a number of people will have to apply. The law makes provision for the surviving spouse, surviving children, and the family member, at least 4, maximum of 4, to apply for letters of administration before they will share in accordance with the intestate succession law. But in between, before that is done, it's an offense for the family to harass the spouse and children in the house which is supposed to be going to them. The one house, whether it's the only house or at least if it's in a number of houses, one is supposed to go to them. You can't harass them out of it. Even if the house is rented, there are provisions for protection for them, and it's very important to also remember that.
Okay.
So that's what I would like to add to that.
So William, we will take your addition if there are any. And then I've seen that there's a question here that says that is a spouse automatically entitled to inherit property if there is no will? And I think we have dealt with that question. So yes, William.
My only addition to what my Lord and Mrs. Premo have rightly stated is that indeed, when you come to making a will, like my Lord said, it gives your family a fighting chance. Now, mind you, it does not mean that the said will cannot be contested.
Mm-hmm.
When you meet a family member who is a litigant, believe you me, they are going to contest the will when they find out that they are not entitled to any property upon the death of the testator. As my Lord said, when you make a will, when you die, you are known as the testator. Upon the death of the testator, a will can easily be contested by any member, because mind you, when you die, the will does not necessarily take effect. There are procedures you must go through. It must go through what we know as probate. You go to court, the will be read, you go and then you get probate. Now, if a family member is dissatisfied, the family member can now come and contest the will in a probate action. So yes, it is not clear, it's not direct, but then at least it gives your family a fighting chance to prove that indeed the will is valid, rather than let them go through the whole PNDC law, the requirements under the PNDC law, where you now have to come and contest, yes, this is a matrimonial property, no, it is not, yes, it should be shared 9/16, 3/16, let's go and value. At least it gives them a fighting chance, but it can't be contested. So that's mine.
Okay, so very, very interesting thoughts shared this afternoon on this platform. I've seen Mary Ann Asare. Mary Ann Asare, if you are minded to ask your question now, you can unmute and then ask your question, and then whoever it is directed at, we will get an answer for you. Mary Ann Asare. I see that Marianne has unmuted, but we are not hearing her. Can we hear Norman? Norman Williams, can you unmute and ask your question? Okay. All right. Let's also try Pat. Pat Omari, can you unmute and ask your question? Yes, I see Pat has unmuted. Okay, Marianne has unmuted, Pat has also unmuted, but we are not hearing them. I believe the technical team will address that so that we can hear. But let me come to the audience here, present. Is there anybody here who has a question? If you lift your hand. Yes, okay, my lady here has a question. Please, let's hand over the microphone to her. And you mention your name, what you do for a living, and then you can ask your question. All right, so the microphone is coming. All right, thank you, and thank you again. So if you are listening to us, you are on Asasi Radio 99.5 in Accra, 100.3 in Cape Coast, 98.5 in Kumasi, 99.7 in Tamale. You are also on the MPOBB Zoom call this afternoon. Is the MPOBB Academy webinar series. We are discussing when love meets property, legal rights in marriage under Ghanaian law. I believe that the three resource persons on this platform have really prosecuted this title, and I'm excited about the contributions. Can we have Our Lady, or can we go back and try on Zoom to see whether or not we can have a question? Let's start with Mary Ann Asare. Mary Ann Asare, can we hear you? I think I can hear her speak, but we are not hearing them. Okay, that's fine. Let's come here and let's give the microphone to Our Lady here. Is the microphone available? Okay, come for my microphone. And please give it to my lady. Please mention your name, what you do, and then your question.
All right, thank you very much. My name is Rosemond Enyonam Dusu, and I'm with the Family and Estate Planning team of Minkah-Premo. So my question is directed to my Lord. My Lord, I would like to know whether prenuptial agreements are constitutional in Ghana in light of Article 22 of the 1992 Constitution, which guarantees the property rights of spouses, ensuring that they have equal access to jointly acquired property during marriage, and that such assets are distributed equitably upon the dissolution of the marriage. So, for example, if the parties enter into a prenuptial agreement, and during the subsistence of the marriage, they jointly acquire property. However, in the prenuptial agreement, let's say the man says that any property acquired during the marriage belongs to me alone. How do you deal with that in light of Article 22, since the woman also contributed and is entitled to the distribution during the dissolution of the marriage? So that's my question.
Yes, you can only make provision in respect of property where you are the owner. But Article 22 is talking about joint ownership, jointly acquired. So something belonging to the two. How can one person lay claim? I don't think it will be right. It will be unfair. So in that situation, yes, prenuptial agreement is encouraged. Like Madam said, like you go to America, there are instances where the court may find that, no, this prenuptial agreement is contrary to the provisions of statute or the constitution, or is inequitable, and for that matter, will not apply it.
So you have a follow-up question. Okay, please let's give her the opportunity to ask her follow-up question. Is there anybody else in the audience who has a question? Please raise your hand. After that, we can come.
In light of the fact that it's usually the court who determines whether or not a property has been jointly acquired, so that is always in contention, usually during divorce. So what if the parties during the marriage are at the stage where the marriage is being dissolved, are now saying that, okay, this property was jointly acquired, but one person says, it was my individual property. How do you deal with that? That is my confusion. If already in the prenuptial agreement, one person says that the properties acquired during the marriage are solely mine. However, during the marriage, the woman might have also contributed. Maybe if not the monetary contribution, with the domestic work and taking care of the house and all that, that is her contribution. But the man says, okay, because I'm the one bringing the money throughout the marriage, the property belongs to me. So upon dissolution of the marriage, it belongs to me. How will the courts determine such an issue? Thank you.
Because issue would have been raised, the court will have to take evidence to know who is speaking the truth. So it will bother. Normally, prenuptial agreement, the court will be prepared to enforce it where it is agreed, oh, this property, Lawyer Jau entered the relationship with it. So the other person will not even be contesting. But where it's being contested, obviously, the court is duty bound to go into the bottom of it to know how the property was acquired and whether it satisfies as joint acquisition or not.
All right, we have another question in the audience, but just before we do that, let's try online again. Mary Ann Asare, we are in your hands. Can you ask your question, please?
And for a period of 10 years, you didn't build any property. All you did was increase the amount of money in your bank account. So assuming it increased from maybe 200,000 to like $30 million. During the divorce, would the amount of money in your bank account considered as matrimonial property for it to be divided? Because I really haven't seen a situation where they are talking about the money in your bank account as matrimonial property. So that's the question I would want to ask, my lord, to get a bit of clarity on that.
Thank you very much. The court, if you go, please look at section 20 of the Matrimonial Causes Act. The court has, even where there are properties, the court can make an order of settlement that pays so much. It's within, so where evidence suggests that you had such an amount but you did not build any property, the court can make an order for you to pay. The settlement and the property move together, and the court can make an order either way. I don't know whether. And so if there's evidence that, oh, this man, he came into the marriage with Wadanso Nani Titeho, he doesn't want to put up any immovable property, so that the court can compel you to pay a lump sum as financial provision. So either it's financial provision or property settlement, any of them goes, and is for the court. It's a discretionary matter for the court. Even where there's property, the court can say that this house, if we are to share it, and we share, let's say 4 bedrooms, you take 2 and the woman takes 2. What if the woman go and marry and bring the new husband there? Obviously there will be war. So the court can make an order for one party to pay off the other.
Very interesting. And for those of you who are online, particularly on Zoom, who have raised your hands to ask a question, you need to step away from your listening device. If you don't step away from your listening device to ask your question, I think we will have feedback. And so we will try again with Mary Ann Asare for one more time to see whether we can get you to ask your question. Mary Ann Asare, please go ahead with your question. Okay. And then we try Thelma. Okay, yes. So we can hear someone. Please identify yourself. Yes, we can hear you. Please go ahead. Ask your question. That question is noted. Let's take Norman. Oh, that was Norman. Okay, so that was Norman. Can we try Thelma? Let's move on from Thelma. Thelma, can you hear us? Okay, what about Marianne again? She's typed her question. Okay, in the chat. All right. So Marianne says that Cynthia, am I looking at the right question? Okay, so can the panel please address the types of wills and what exactly a minor a mirror? Okay, a mirror will is. Hey, mirror will. I've never heard that before. Okay, all right. So Marianne, your question is noted. Which other question do we have? Okay. Unfortunately, it's quite a little bit of a challenge for me to read from where I'm sitting. I'm sorry about that. But please, okay, no, this is not a question. It says that can the host unmute? Somebody is asking us to unmute so that that's Thelma. Okay. All right. Let's have my Lord answer the question that was asked by Norman, and then we'll take some time and see if we can get some other questions. And then also the one asked by Marianne. Is there anything like mirror will?
All right. So the question he asked had to do with rebuttable evidence. He said where evidence is led. When we talk about rebuttable, the lawyers and the law students know that in the Evidence Act, where let's draw a distinction between facts and evidence. Where you come to court to say that, for example, if a person is not heard of for 7 years, you come to court like Castro for 7 years. Then the law draws its conclusion. No evidences. You just need to present the facts, and the law would draw the conclusion. So that is what we mean by presumption. But there are two categories of presumption. One which is rebuttable and the other which is irrebuttable, or conclusive or inconclusive. The rebuttable presumption is once the fact is led or is stated, that the court will, or the law will draw a conclusion which will not allow the other person to establish facts to negate it. So immediately it shows. For example, you sign a document. You sign a document. The presumption is that you read everything, or you create an impression that this mobile phone does not belong to you. So I tell my brother that I'm selling it, and you allow me, you allow me to sell it. You cannot later turn around to say that I'm not the owner, or you are now the owner, when your action had suggested that I'm the owner. So where the facts come to the fore, then the law draws the conclusion. So in the same vein, once you come to court and property is deemed to have been acquired during the subsistence of the marriage, we form the impression or the opinion that, oh, if you married 20 years ago and the property was acquired 10 years ago, then we presume that the two parties jointly contributed. At that stage, I can come and say that, no, as for this property, it was my mother who willed it and he died, who gave it to me. So the other spouse does not come in at all. He had no idea about how it was acquired. So that it will mean that I am leading evidence to change the mind of the court. That is what we mean by rebuttable evidence. Coming out with evidence to change what the law otherwise would have presumed. All right. He also asks whether an unregistered lease in the name of two persons can be enforced. Yes, once the property is in the two parties' name, whether it has been registered or not, the court will form an opinion that from the word go, the two parties jointly acquired it. If it was for only one party, he would not have allowed the other person's name to be on it. So the hiding behind the non-registration may not save the person.
Okay, my lady, I want you to answer this question that has been posted by. Okay, that question has left the screen. If you could help me with it, it's Abigail. Abigail's message. Abigail's. Okay, there's the mirror. There's the mirror question. One. Yes. So you can answer that. No, please go up again. There is a question there. It says that during a divorce, can loans given to a spouse by the other spouse be added? Okay, I think we need to. I'm sure it is added. Okay, added to the reliefs sought in the divorce for the monies to be paid back. Yes. Okay, I've struggled to read, but I hope it makes sense. So, madam, if you could answer those two questions, this one and then the mirror will question.
Okay, thank you very much. I think Thelma asked a question as to the types of wills that you can make in Ghana and whether you can. There's something called a mirror will. So basically, we have a law, the Wills Act. Act 360 sets out the procedure for making a will, and once your will that you make conforms to it and does not fall short of any of the provisions, it will be enforced by our courts. In terms of mirror will, I'm not really sure what it is. So for me, what I'll say is that it is just important to make sure that you conform to the provisions of the Wills Act, and definitely that will be enforced by the courts. Then someone is asking a question. I think it's gone. What was the question? Was what?
Is it the one I read to you?
If there's a loan.
Yes. So the person is saying that during the divorce, can loans given to a spouse by the other spouse be added to the relief sought in the divorce for the monies to be paid back?
Yes, it is possible. It's at the point of divorce, whatever claim one person has against the other, they have a right to add it to the reliefs that they are seeking. So it is possible.
Okay. My lord.
Yes, I want to add that as the name suggests, it's a loan. So from the word go, the intention was clear that you would repay. So if it's a loan, why do you have to run away from it? It's different from, so let's say your excuse me, your mother was sick and you said, I need a loan, and I gave it to you. Why do you want to run away unless I volunteer? Oh, you come to me and you tell me.
Most of it are not those kind of loans. They don't come with any agreement.